Okay, I have started the recording, and we'll get going here with this, the other part of this two-part series of webinars on dissolution, child custody, and domestic abuse. This part is simply going to be dealing with the legal piece and not so much about advocacy issues. It's kind of the background. Here's the way it works here in Iowa. So your mileage may vary if you're working a program that is on a border that, you maybe have clients that are in Nebraska or Minnesota or whatever. I cannot speak to those states' laws. State laws vary quite a bit, particularly in civil matters. But I can tell you at least what I know about the information piece of how it works in Iowa. And I'm hoping that you all can hear me really clearly. I have a brand new headset, so yay. You are on mute. However, you do have the option of raising your hand, and so there's a little button for you. If you hit that, I can either unmute you if you want to voice your comment or your question to the whole group, or you can type in chat and I can see comments that way, and I will try and pay attention to that. You should be receiving, if you have not already, a copy of the PowerPoint that is already loaded up to go out as a handout as part of this. And as always, I am recording this and I will be making it available on our YouTube page. And to start off with, particularly for people who might be seeing this at a later date, nothing that I'm going to say is legal advice. I'm really just going to attempt to give informational background on the process, talk about what the code says, but how that would apply to any particular person's case, it can vary broadly. And so what would be best in your interest or in a particular client's interest, I really can't say. So if you're looking for pure information, hopefully this will provide some of that. If you're looking for, okay, now what should I do? I would say check in with an attorney. And just because there's a lot of information here, just wait for the occasional pauses with something to something to break the monotony. To start with, we're really kind of talking about three processes that operate pretty similarly. Dissolution is the legal term used for divorce, and I will use them interchangeably. And so you have a valid marriage, and that marriage is being terminated. An annulment would say that the marriage never really existed. It wasn't valid. One of the few examples of that might happen would be someone got married and then they find out that their partner was actually previously and still currently married at the time that they married them, and so since polygamy is illegal in Iowa, that second marriage is technically illegal and doesn't exist. So that marriage could be annulled. Legal separation, the couple is technically still married under the law. They would still be considered married for things like tax purposes, but they are living separately. And so the court will figure out how to make that, what are the boundaries and how do you separate those lives in an equitable way. So who might get property, what's the custody arrangement going to look like, things like that. That isn't used a whole lot. Where it is typically used is in situations where there might be religious or faith concerns that say that we don't want to be divorced. Divorce is not possible within my faith, but we no longer want to live together. And that's the few times when you might actually see a legal separation instead of a divorce. So I'm mainly going to be focusing on the part of the Iowa Code, Chapter 598. That's where the whole process is laid out. And if you have some questions, sometimes it's helpful to go straight back to the code and read what it actually says there. At least I find it helpful. Sometimes it's helpful to fall asleep, but sometimes it's helpful in other ways too. And like most legal processes, everything begins at the clerk of court's office. You can file for divorce in the county where either of the partners resides. So if you're working with somebody who has moved away from their spouse, and even if they are in, they're staying in shelter with you, they're residing in that shelter, then they could file in that county. You're filing a petition with the district court. Only the district court has the power to hear these kinds of family law cases. It will not be the associate court. Though since Iowa has a combined system, it might be that you saw a district court judge dealing with some lesser matters, but anyway, it's district court. There are fees. You can ask to have it waived. You can ask when you're filing, you can ask to have it waived. You could also ask to have those fees assigned to the partner at the kind of final decision. And then anytime you have the sheriff serving papers, whether that is serving the actual petition or serving some kind of a paperwork for a witness to come to a hearing, there's going to be a fee. And again, I'm taking a little stab in the dark about these fees. For all I know, it changed yesterday after I had put this together. So about a $50 fee each time you ask the sheriff to do something. So you have to file a petition. What do you need to tell the court? Well, here's the checklist, and I'm not going to necessarily go through it word by word. Word by word is in 598. If you go there, it says exactly what information you have to give the court. Certainly the personal information about where you live and where the marriage took place. I'll talk about common law marriage in just a second. If there's any kids that are going to be affected by this, you have to give information about those kids and also make it clear whether or not there's some other case that is co-occurring with the divorce that would impact the custody of those kids. There's a phrase that you allege that there's been a breakdown of the marriage relationship to the extent that the legitimate objects of matrimony have been destroyed and there remains no reasonable likelihood the marriage can be preserved. That language is usually just cut out of the code and plopped down word for word in a petition. So if by any chance you're working with a client, because I've had this happen too, you're working with somebody and their partner files against them and they get this petition and it says this, that language might seem very harsh to some people. It might seem kind of alien, whatever. The partner isn't generating that. It is just standard rubber stamp language. Here's a place when you're first filing to ask for temporary support. So I want a divorce, and while this is all being decided, I need assistance with paying, continuing to pay our mortgage or our rent. I need temporary child support. I want to have primary physical care of the children while this is being decided. Here's what I would like to see as far as temporary child visitation arrangements, if that's something that your client might want or not. Here's who should pay the attorney fees. And by the way, I need I need one of the family cars, and I need my passport, kind of like the things that you might file with a protective order, all of that needs to go on that initial petition. So that's a place to spend some time thinking about what is going to be required between filing and a final decision. And this can take many, many months. In some cases, can take more than a year. So what is really necessary for that person to get by during this, while this court case is pending? Now, you have to either be a resident of Iowa, or the person that you are getting divorced from. The person who is filing the petition is the petitioner. The person who is going to be getting the paperwork and has to respond is the respondent. And one of you has to have lived in Iowa for the last year, and you didn't just come to Iowa for the divorce. Like, there have to be other reasons. I'm not aware of people like coming to Iowa to get divorced the way people go to Las Vegas to get married, but it's in there in the law. And we are a no-fault state. In other words, you don't have to prove anything. You can just say, hey, I don't want to be married to this person anymore. You don't have to show infidelity or domestic violence or substance abuse or any of the other things that in the past had to be presented as some kind of a reason why you wanted to be divorced. Iowa does have common law marriage, and there's a couple criteria by which a judge would be looking at, okay, do they fall under that or not? Part of it is, do you present yourself as married? Are you living together as if you were? So are there joint bank accounts? Did you buy a home together? Do you present yourself to family and friends? Do you have, one person is named as the beneficiary on the other person's life insurance? Any kind, there are lots of different things. Where do you live most of the time that can go to saying common law marriage? And if you are common law married, you're going to need a divorce. So what if you're working with somebody and they don't know where their partner is? They've kind of disappeared into the woodwork. They're trying to avoid, a number of different legal issues, and maybe divorce is one of them. If the sheriff can't find them to give them the paperwork, then you can do a couple of things. You can show that you've essentially made best efforts to try and get a hold of that person by giving them and sending all of the papers by registered mail to the most recent address. So then you get a notice back from the post office saying that, yes, they have tried to deliver it and that person isn't there. And then publishing in the legal notice in the paper. So if you look in want ads and everything in your paper and you see legal notice, legal notice, legal notice, that's where often where the other party can't be found. And so this is a way of trying to show, again, that you've done your best to give them the information that this is happening. Okay, next one. Click, click, click. And Kirsten, drink time. So you sent the paperwork, and the sheriff has served it to your hopefully soon-to-be ex-partner. That person has 20 days to respond, and they have to respond again at the clerk's office in writing. There is a 90-day waiting period then that begins. So you can do the math as we go of what the minimum and maximum is, but there's a maximum of 20 days to file a response, and then a minimum of 90 days after that response before there can be any kind of final decree. The legislature wanted to give 3 months for reconsideration so that people can try and reconcile. The legislature is of the opinion that marriage should be preserved if at all possible, and so it is their belief that by putting in mandatory waiting periods, they're making it more possible that people will change their mind. So you have 90 days if you agree. If you don't agree, then it's time for a hearing. So essentially a trial about the divorce. So there's a lot of stuff that happens during that waiting period. For one thing, if either party asks, then you can be sent to marriage counseling or conciliation, same thing. The court can also just decide on its own that it's going to require that. And then that person that is the counselor needs to file some kind of report saying that, yes, you contacted them and some effort was made and that you followed through with the requirement. This is somebody so in other words, you might be working with someone and their batterer says, hey, I want marriage counseling, and the court says, okay, I'm going to order that. And they're like, wait a minute, do I really have to go to counseling with my batterer? Well, yes, and you have to pay for it unless the court will say, okay, you can't pay for it, so the county will pay for it, or unless you go to the court and you ask for a waiver. And in order to do that, you have to demonstrate, you have to give evidence that domestic abuse exists. So what that means is that up front, you have to be willing to kind of share the dirty laundry. So for some people, that's not a problem. That works. They're like, I want to get it right out there and have the protection of the court so I don't have to participate in these things. For other people, if I have to go immediately and share that, then the risk escalates because now I'm talking bad about the batter in public. And it's a real catch-22 there of whether or not that waiver is helpful or not, depending on that particular person's situation. The conciliation can last for a minimum of, can last for 60 days. And then that waiting period starts all over again if the conciliation was ordered. There are some districts in Iowa where it is required to participate in mediation. Most districts are moving that direction. Overall, mediation has been shown to be fairly helpful for divorced couples in coming up with their own agreement that actually fits their circumstances, and that they are invested in because they generated it rather than it being kind of a one-size-fits-all rubber stamp thing done by the judge. It's also way, way cheaper to do it this way than to spend more and more money in attorney fees and everything else. So for those parties who can make mediation work, it has been a really helpful solution. However, there are some parties for which mediation is not so very helpful, and that often can include people with a history of domestic abuse. Either party, again, can ask to mediate, and if somebody asks for it, it will probably be ordered, and there's also a good likelihood that a judge will order it whether somebody's asking for it or not. And as I said, in some places, it's simply a mandatory part of the process. Now, once again, there is an outlet, a doorway for survivors of domestic abuse to say, hey, I don't want to do this process, and they can go to court and they can show that there's a reason why that domestic abuse exists, and so therefore they might be in fear or it's not going to work for them, and a judge can waive that requirement. And the exact same issues apply. For some people, that's going to work great, and that will be to their benefit, and for other people, that might escalate risk. They don't want to talk about this if at all possible. They're trying to keep it out of their case and kind of just get it done as quickly as possible, and the waiver system doesn't work. So entirely depends on that person's situation. Okay. So I said that for both of these situations, the court has to say, has to make a finding that domestic abuse has occurred. So what does that mean? Well, then you go to 598 and you say, what does 598 think as being domestic abuse and how do you show it? And these are some of the ways that it can be shown. If somebody has filed for a protective order, or if a protective order or consent agreement was issued, if there was a violation of a restraining order, if the police have come to the home, if there's been an arrest, if there's been a conviction for domestic abuse. You might also be able to show medical records. You might be able to show affidavits from a counselor, something to substantiate. You might be able to show photos of injuries, all those kinds of things. Now, when I said that you have to participate in mediation, participation doesn't necessarily mean that you have to sit there and work out an agreement with the partner that has been harming you. What it means is that you participate with the process. You talk to a mediator, you learn about the process. In some places they have classes that are, here's how mediation works. So maybe you go and you attend the class and you've learned more. Either party has the right to end mediation at any time, and you don't have to have some kind of signed written agreement at the end of the process. So you can go, you can learn, you can sit down and begin the process and say, you know what, this isn't working for me, I don't feel good about this, I'm going to stop it right here, and you're done. You don't have to do anything more. So that is another, like the waiver, that's kind of another safety net for somebody if there's issues with participating in mediation. If, however, let's say you go through the mediation and you come to some kind of an agreement, but later you're like, no, I was intimidated, I was scared, I was simply agreeing to get out of there as quickly as possible or de-escalate my risk. There's other safety nets. The agreement has to be given to the attorneys to look at, and sometimes people will agree to stuff that isn't even really legal under Iowa law. So the attorney can go, you know what, no, that's not going to work. And even after that, it isn't enforceable. It doesn't really have the power of law until the court has taken that agreement and signed off on it. So there's some pros and cons with mediation, and this is one reason I have been doing training for mediators for some time now. Some of the pros, it can help de-escalate because you're dealing with issues. Mediation is confidential, and so it's like a small confidential process. So if my batterer doesn't want me saying anything in court, if my batterer has basically threatened me, if I reveal anything, I'm scared, maybe this is a process where that cover of confidentiality will decrease the risk. It might be that I feel like I'm in a position where I'm more safe and secure, and I actually want a chance to state what I want and to have a voice and have some kind of power in the decision making. Mediation is the place that can happen, as opposed to that kind of letting a judge decide for my family. It's also a much cheaper option, right? The cons, of course, as you can predict, are things about power that, if you are going to be mediating with somebody, it assumes that you're coming in with basically an equal amount of power. And there are some things that mediators do all the time with any parties that they're mediating with to try and balance power so that everyone has a chance to express what's important to them. But how far can you really do that when there's a history of domestic violence, when there's a history of fear and domination? Another thing is that mediation may be simply a tool by which the batterer is getting one more opportunity to have proximity with their victim, to threaten, to have an exchange in the parking lot, you name it. So um, it might be used as a weapon. There's the issue of, can you really put a lot of faith in anything that a batterer agrees to, because they make promises all the time when it's convenient and then don't follow through. So if they just feel like they're doing this as a way to manipulate and look like the good guy, do they really have any intention of following through on any agreement that's reached? So there's a lot that we could go on and on about as far as pros and cons. It's going to depend on that particular person and their situation, what's going to work for them. Okay, time for another drink. That cat looks so much like my cat, Arthur. Except my cat's way too fat to squeeze through there. Another thing that's going on in between that petition and the hearing date is the children in the middle class. Again, the legislature thinks that this is an important attempt to get parents to limit the negative impact of divorce on kids. And so this is where you're supposed to learn about needs of children, where you're supposed to pick up some skills for co-parenting and for communicating with the other parent when you're now living separately. And there's a large part of it that is about pay your child support, and by the way, pay your child support. You have a limited amount of time to get this class in. The fees vary widely and the way it's presented vary widely. But you have to have a certificate showing that you have done it in order to proceed through the dissolution process. This can be hard if you are trying to get your perpetrator to do it and they don't want the divorce. There's many reasons why they might not manage to get this in and hold up the whole process. And we can also talk about the fact that there might be, because there are limited opportunities for it, there might be times when you have both parties in a domestic abuse dissolution case attending the class at the same time. Again, is it a way for that perpetrator to again have proximity, to again intimidate? Yes, that can absolutely happen. So I mentioned some of the things that you might want to ask for at the very beginning if you are filing a petition. And there might be hearings in the middle until you get to that final hearing for the decision to settle those kind of temporary matters. So you say, hey, I want temporary custody of our home. I want to stay here with my kids. And the response, that respondent sent says, I paid for it. It's my home. I'm staying there with the kids. You're the one that wants a divorce. You need to move out. So there might be any number of hearings and negotiation and everything in this meantime part. So things that you can ask for, the court can order, again, cars, house, not only child support, but also spousal support temporarily. I'll talk about guardian ad litems in just a second. Visitation arrangements can be set up. What I would say is that anything that is set up or anything that is asked for or any visitation or custody that is agreed to during this temporary matter is going to channel very much into the final decision. In other words, if you were to say, okay, I've separated from my batterer and they're really mad right now. However, they're also trying to look good, and so they're playing the game, and so it feels like things are safer right now, and it would be okay for, I feel safer about having the kids go and visit because, he's living with his parents, and so there's other people there, and he's trying to look good for the court, and so here's a chance, and the kids really want this chance during this chaotic change time to have a lot of interaction. So I'm okay with that. And it will probably go well under that circumstance. At the end of that, it's really hard to go back to the court and say, oh, no, 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 this is not going to work long term because I have all of these fears about what's going to happen. The court's going to say, everything seemed fine. This has been working, so why should we change it? So that's kind of, I guess I said I wasn't going to get a whole lot into advocacy issues, but let's just say that often the temporary kind of sets a tone that will carry over into the final custody agreement. Guardian ad litem sometimes is just abbreviated to GAL, so that's a guardian before the law, is somebody who represents the kids. So you have mom's attorney, dad's attorney, and now here's somebody who is specifically assigned by the court to be kid's attorney. They have a lot of power. They can bring in their own witnesses. They can make their own investigations. They can attend any kind of hearing or event, that meeting that affects their child client. I would also say that in my experience, most of the guardian ad litems don't actually use all of that power. Sometimes they never even interview the child. Sometimes they just show up at court on the date for those hearings simply to make sure that their client is represented according to the letter of the law. It can be all over the map, whether or not that is something that is helpful or maybe not so much to a child. The guardian is assigned by the court, and the fees can be paid for, again, at the end, whichever parent, or it's split between the parents to cover that third attorney fees, or if it's shown that the parents can't afford it, there is a county pot that can help pay for that. Time for another drink. Where are we at for time-wise? Okay. Other things going on at this point. Discovery. The financial discovery is often one of the hardest, and it's a lot of paperwork to fill out. Figure out all of your assets and trying to get that information from the other party if they are wanting to hide assets so that they maybe don't have to pay so much support. This may be a place where there's a lot of contention and sometimes fighting over property and what that property is worth that is not necessarily financial but can become more symbolic. So there's financial disclosure, mental health records. If your partner wants to come in and say, look, this person is crazy, or see, they're a bad parent because they've been in counseling or they're on psych meds or whatever else, there's a lot of leeway to have to disclose those mental health records. Again, like a criminal case, discovery exists so that each party knows what might be used against them in a final hearing. And as we know, batters, hey, where'd it go? Are really good at building cases and really good at collecting grievances. Alrighty, I keep saying there'll be a hearing, there'll be a hearing. There's a hearing, a trial, if you will. And it's like any other trial, has the opening statements, each side gets to present evidence, each side gets to cross-examine, there's closing arguments about what each side wants. The standard is different than in a criminal. It is the usual civil standard of preponderance of evidence. So is it more likely? Is it, 51% or 60% more likely? That is the standard that the judge is going to use to decide these cases. So the judge hears it, and again, like in criminal cases, there's the trial, and then you have to wait, and then you hear the decision, and then you have to wait, and it could be a long time until the actual sentencing. So you have your trial, and then you have to wait, and sometimes a long time, until you actually get a decree where a judge comes back and says, okay, here's the split as I'm going to order it. Again, if there has been a mediation agreement that's been agreed upon by both parties, the judge is typically going to follow that agreement really closely. The only part where they're more likely to deviate than not is if something that's in that agreement actually is not okay under Iowa law, and usually that's stuff around child support. So the judge will decide who gets what. The judge will decide custody and support and alimony, which again I'll talk about. And in order for the judge to file that with the court, there's a $50 fee again. So you're paying $50 for the judge to make that official decision. And again, I haven't been keeping track money-wise, but maybe you have. So alimony, you can't, for child support, there is a lovely little chart where you can kind of eyeball it and figure out where the baseline's going to be. There's nothing set for alimony, and it's rarely ordered. It isn't like so many things. It's not like TV. Where you may see alimony ordered, it's going to be in Iowa. It's going to be temporary, and it's going to often be about helping if after this divorce one party is significantly impacted economically, it might be about helping them get back on their feet. So the perfect example would be, we had an agreement when we got married that I would put you through college and I would work, and then when that was done, then while you were working, I would have a chance to go through college and I could then start my career. And what has happened is I worked to put you through college. Now we're getting a divorce. What happened to my turn? And the judge might say, yeah, in order to be fair, you're going to have to help pay for that college education, or you're going to have to help pay for temporary maintenance for X number of years until they can get on their feet. Or, this partner has been out of the work field for so many years, and you'll need to pay 2 years worth to help them go to community college and get their computer skills back up so that they can be competitive in the job market. So it's usually about a temporary adjustment of kind of the consequences of that marriage. And it's going to depend on a lot of things. It's much more likely to be ordered for longer marriages, things around work history, education. If you have somebody who's like leaving that marriage with most of the property and everything's great, and you have another party who is significantly undermined, then you're more likely to see it. But not like TV. Child support, dun dun dun. There is a chart, and you can go let's see, where's their income, where's the other person's income, how many kids, and it will ballpark roughly what that non-custodial parent is going to be paying. This is based, again, on the Iowa legislature saying, if you have a child, you have a responsibility as a parent to pay for the upkeep of that child. It's extremely, extremely rare that no child support would be ordered, because this is pretty much, it's a standard formula. So that formula kind of gives the baseline, and then judges can move it around a little bit based on other circumstances as might be particular to a case. let's say that both parties agree, and this is something that often happens. Both parties will agree, hey, no child support. I just want to leave. Just, you can have the house, you can have whatever. Just give me custody of the kids, and I won't ask you for any money. You'll hear that often. Doesn't matter if the parties agree to that or not. The judge is simply going to order the child support regardless, which in itself is kind of nice if somebody um, is trying again to de-escalate their partner by saying those things, even if they're saying them truly believing it. It takes the burden of requiring that off of that survivor and places it on really the legislature. Come on, click, click. There we go. So the child support is based on custody. Let's just do a little definitions around custody. Legal custody means, hey, I have legal rights to this child. I'm legally considered a parent. And so I have the right to have a say in their medical care, in where they go to school, in what sports they participate in whether or not they're in Boy Scouts, in what church they might attend, those kinds of things that are about parental decisions about raising a child. If I have legal custody, then I have a say in doing that. Sole custody means that one of the parents has all of that, has all of the legal authority. You don't see that ordered very often, and even in cases with child abuse or cases with domestic abuse. Instead, what you usually see is what's called joint custody or joint legal custody. It's essentially the same thing, where you have two people who are sharing that legal responsibility. Supposedly, those are equal, um, and one person doesn't have a greater say in that than the other party. Um, this is the preferred situation by the legislature. It's the preferred situation by the court. And again, even if the parents don't want this, even if one parent is like, hey, I'm out of here, I don't, take the kids, whatever, I'm done, the judge is still probably going to order joint legal custody. Um, there's that idea of, hey, you are responsible for this child and you can't just toss over your responsibilities. So there's custody, which sounds like I have the child because of that, that word suggests I have the child, but that's really about legal responsibilities and legal rights. Separate from that, or beside it, is the issue of physical care. And so primary physical care means just that. One person has most of it, but the other person might have part of it. So I'm primary physical care. I might have almost all of it. The other party, even if they have we have, I have primary physical care, and that means that I have them 55% of the time, and my partner has them 45% of the time. That other partner will still be considered the non-custodial parent, whether they have them 1% of the time or 49% of the time. Primary physical care, non-custodial parent. Joint physical care means both of them, it's shared, it's equal. Sometimes this is called shared parenting. Typically what you'd have is the kids spending half the time in one parent's home, half the time in the other parent's home. There's a trend right now, which I can't remember what it's called. It's like called shared house or something, or shared nesting, where instead of having the kids go back and forth between home, the kids stay in one home and the parents have to move in and out of the kids' home essentially, and share parenting that way. This can present some concerns for anybody. There's some developmental concerns for any kids around this, but particularly when you have domestic abuse, this is an issue. If either parent requests joint or shared custody and shared care, oops, back, wrong direction. If either party requests this joint, we both are taking care of them in the day-to-day, the court is well within their rights to award it. They often will, even if the other party doesn't want that. Part of this, when they do order that, is that you have to present some kind of a parenting plan, and there may be a counseling process that's required to generate that plan. So here's how we're going to make that work. If the court denies a request for joint physical care, they have to specify why they're not giving that. Basically, there's been a move in the legislature to this being the preferred. And so if a judge is going to deviate from that, the judge is going to have to say why. It'd be better if this was not the preferred, and if a judge ordered it, the judge had to say why they thought it would actually work. There is, and this is my opinion, that for parents who are separating, for whom they can make this work for their kids, and there certainly are some where they're willing to cooperate, where they can communicate, where they can put the needs of their children first, where they can be respectful and amiable to each other. The process absolutely exists to make it happen and make it work for them. Not an issue. But for all the other parents for whom this isn't going to work, and particularly for survivors of domestic abuse, to make this be kind of the norm presents a lot of problems. I mean, if a couple was not doing well as parents prior to the divorce, what makes you think that after they've separated they will do better? That makes no rational sense. But this has been very much a push in legislatures around the country, often by fathers' rights groups, to assert that no matter what, I still need to maintain primary control over my kids. So how is a judge making these decisions? Well, the standard is best interest of the child. And again, it's always interesting to go back to 598 and say, well, what is best interest of the child? Well, there's a couple things there. Maximum continuous contact with both parents, unless there's some kind of danger in that. That's one thing that is considered to be in the best interest of the child. And if one of the parents refuses to provide that, in other words, this is the idea of a friendly parent or an unfriendly parent. If you're an unfriendly parent, if you try and interrupt maximum continuous contact with the other parent, there's a lot of reasons why a parent may not want that. There may be issues of domestic violence. There may be issues of child abuse, child sexual abuse. So that puts a parent who is having some concerns over the children's safety often in a negative light, because they're then the unfriendly parent. So they're going to have to justify why it is that they have those reservations. Other things that go into best interest: who is best suited to raise the child? That's all it says. What does best suited mean? Your guess is as good as mine. Who has actively cared for the child in the past? So who has been that primary caregiver? Who knows the child's routines? Who knows the daycare provider and the doctor, and et cetera, et cetera. Again, who is in a better position to be a friendly parent? And this is someplace that batters often come off looking really well, because they're always like, oh, they have no problem with that. And of course, and they're so worried about their partner's mental health state that makes them so unusual. But absolutely, they understand the importance of that relationship and want to encourage it. Will kids suffer from a lack of contact with a parent? There's a belief out there, a complete myth, that children, or children at a certain age, like I often hear 16, that you get to say which parent you want to be with, and that's simply not true. Some judges might pay attention to a child's preferences, but um, not really there. The most you might have is, will the child suffer from lack of contact with a parent, as far as what does the child want. Um, if one party is relocating, is that going to affect how easy it is for the other parent to continue contact with the child? That might be part of this. And certainly child abuse and domestic abuse are listed. Sometimes people want us to help them terminate the other party's parental rights, and that is a very hard process. Again, there's a standing a value, an ethic of the legislature in setting the laws that parental rights are upheld as being extremely important, and that if you have a child, um, you have a right to have some kind of control and say in their life. Similarly, you have a responsibility to help in their care. So these are the things that are listed in the code as reasons why you can terminate a parent's rights. A child being abandoned, if someone is a felon in prison for at least 5 years, in other words, they're going to miss a significant portion of that child's life, and the contact is essentially not significant. Abuse or neglect, and that is really abuse or neglect of the child. We're not talking abuse or neglect of the other parent. The person who is doing these things is not willing or unable to correct the situation. They haven't had the child with them for at least 6 months with significant contact. And then there's the whole in the best interest of the child to have that termination. Even with child abuse, even with child sexual abuse, this is sometimes hard to get, if that's one of the things that somebody is aiming for. Now, if there's DHS involvement, Child Protective Services involvement, it might be easier. But and if somebody's in prison, it might be easier. But barring that, to go in for a divorce and ask for termination of the other party's rights, you have definitely an uphill battle. So domestic abuse is in there under best interest of the child. And what it spells out is there is a rebuttable presumption against joint custody if there's a finding of domestic abuse. So we talked about how that finding is made. You actually kind of have to have a mini hearing or a mini, this has to be part of the case evidence that's brought forth for that to simply be for a judge to decide, yep, domestic abuse has happened, and yep, here's the party that is responsible for it. When I hear rebuttable presumption, the word but really sticks out to me. So what this is saying is if a judge has made that finding, yep, there's domestic abuse, and yep, then they are supposed to assume it would not be in the child's best interest to be placed in the custody of that violent parent. But there's the but. So that's the presumption is you presume it's not in the child's best interest. But it's rebuttable. But the person doing harm has been through treatment. But they've been through substance abuse treatment. But they have the greater income, education, and stability. But the survivor parent has very severe PTSD and seems unstable and has a unstable, chaotic work history and is homeless, and is showing all the impacts of having suffered that trauma. There's a lot of things that that parent can do to get over that presumption. So it doesn't close the door if there's a finding. It just says, what's the other parent going to have to show to say, hey, I may be a batterer, but here's why I should have custody anyway. This is an issue that comes up a lot for our folks. They want to move, and of course they do. So if you want to move, I would put that out there right at the beginning of my case. Parent with primary physical care is entitled to relocate, including leaving the state if they want. However, as a non-custodial parent, I can go in and request a hearing and request that there is a change in custody or a change in visitation if there has been a significant change in the situation. And moving out of state or moving to the other side of the state could easily be one of those significant changes. So as the custodial parent, I have the right to move, but I may be opening myself up to having to go back to court and maybe having the custody changed. So I don't have to ask the court first before I do that move, but I have to keep in mind that might be considered, is likely to be considered enough of a change in circumstance to at least have another hearing. Well, what about parental kidnapping? Can I leave the state with my kids? Well, yeah, you can leave the state with your kids unless there's some kind of piece of paper from the court that says that you can't. And that applies to the other parent of that child too, if they are a legal parent. Any parent can leave leave the state or whatever with their kid unless a judge says you can't. So if you are filing your initial petition or if you have a specific thing you want as part of your final divorce, you should probably spell that out. Like, yes, it's okay, we're agreeing on joint custody. However, I will maintain custody of the children's passports, and the non-custodial parent is not allowed to remove the children from the country. Well, actually, the non-custodial, a parent can't remove a child from the country without the other parent's consent, and you actually have to get the other parent to physically show up and provide that consent. But nevertheless, it can be helpful to have that spelled out. So there are laws that specifically address moving children from one state to another. They have long, awkward names. The Interstate Governance through the Uniform Child Custody Jurisdiction and Enforcement Act, the UCCJEA, the Parental Kidnapping Prevention Act. Basically, these are agreements and federal legislation for how states are going to deal with the state-to-state issue. And they cover a couple things. Basically, if a custody order is made in one state, it's good in another state, and the courts there will honor it. So if you have a client who went to court in Kansas and there was one decision there made around custody, you can't then say, ooh, I didn't like that, and come to Iowa and file and try and get a different custody arrangement. The Iowa court will say, no, we are giving full faith and credit to the Kansas court's decisions around custody. Except, and another thing it does is those laws determine which states get to make those custody decisions, and they all agree that they will honor, all the states agree they will honor this. Basically, a kid has to have been living in a state for 6 months. Where they have been living, the child has lived there for 6 months. Within 6 months of the date a custody case is filed, or they've already been living there for 6 months. Essentially, if you have somebody who has moved here to Iowa and tries to file here for divorce, they may live here and they may have, okay, this is the county where I'm living, so I might be able to file for dissolution here, but my children haven't been here for 6 months. We came from New Mexico. That custody case is going to have to be heard in New Mexico. There's some emergencies that are there specifically to deal with issues of child abuse, child endangerment. The court can take temporary emergency jurisdiction over a child who has not been here for 6 months if the child has been in Iowa, if they've been abandoned, or there's that threat of mistreatment or abuse. So you could go to court and say, hey, we fled from New Mexico because of threats of domestic abuse. Here's all of our, here's all the police reports, here's the medical reports. There's danger to the child, there's danger to the parent. If we go back to New Mexico to deal with this custody case, Iowa, please take emergency jurisdiction. So there is an avenue there, and that they may in fact do that. What you can't do is they tried to make it so you couldn't just move a child and hide them for 6 months and then claim that they were a resident. So there's unjustifiable conduct. So the batterer can't steal the child away, or a survivor can't take the child to another state, hide them, and then try and file there. That would be considered unjustifiable conduct. You can also sometimes, and I'm sure this is used, I'm just not familiar with a case where it's been used, you can also file under inconvenient forum, which is basically saying it would be really hard for us to do this in this state, or to do it back in that state when everybody is here. You might have a situation where, let's say the family is here in Iowa, all the extended family, all the witnesses would be called here in Iowa. The child is currently living in Iowa, but up until, say, 2 months ago, the child was at the naval base in Hawaii. And not on the, well, maybe living on the base, but basically had parents and they were stationed there in Hawaii. Really, everybody that's relevant to the case is here in Iowa, even though technically the state that would have jurisdiction over that child is Hawaii. So then you could file for inconvenient forum and see if you could get jurisdiction moved. But by and large, there are there's little avenues. By and large, the case needs to be heard in the state where the child is a legal resident, which means where have they truly been living for the last 6 months. Other domestic violence stuff. You have the right to ask for security in the courtroom if there's a history of domestic abuse. Like, my partner is really unhappy with me, and I'm afraid that if we go to court on this date, I'm going to get shot on the courthouse steps, or there's going to be something that happens in the courtroom or in the hallway. You can ask for security, and that includes a metal detector, that includes having sheriff's deputy in the courtroom, things like that. You can also say for emergencies that you need those waiting periods waived, that it's too much of a danger to wait the 90 days. And here's all a presentation about domestic violence up front, and maybe they can waive that. Another important part of the 598 code for Iowa, when we talk about protection orders and getting pro se orders and 236 orders, and you can get a permanent 236 order, but it's really only good for a year. 598 allows for a truly permanent order. So as part of your final divorce decree, you can ask to have a permanent protection order, or one that's only 1 or 2 years, whatever. I mean, you can ask for whatever is going to work for you. But that's where you can actually have one where you don't have to go back to court every year and ask to have it extended. There may be ways that the financial abuse has been used, and the divorce decree could help address that in terms of restoring credit history, in terms of assigning debts. Um, you can ask for those things. Whether it works is another issue, but certainly to say, one of the things that happened here was my name was forged on these documents to get a credit card or to get that car loan or everything else, and I shouldn't be held responsible for the economic abuse that happened and have those debts assigned to the partner. Um, and there's also with the IRS, this isn't part of Iowa, but I just thought I'd throw it in here and mention that if domestic abuse has been an issue in terms of a partner filing false tax information, you can go in and say, hey, we're separated, here's the history, here's what happened, and get some relief around taxes there and your responsibilities for uh, not being held responsible for tax stuff, mischief and mayhem that may have happened during that abusive marriage. The last thing I want to say is if you don't like the decree, if you don't like what the judge decided, you can't just ignore it. If you ignore it, if you don't follow it, then that can be contempt of court. And contempt of court always means the possibility of fines and jail time. If you don't like it, you can file an appeal within 30 days and ask for it to be amended. That appeal has to be based not on, hey, I didn't like what you said, but on some way that the law wasn't applied correctly or some way that the procedure wasn't applied correctly. You can't just disagree with the decision. You have to point out something that went wrong in the process. Or you can file a petition to modify the order, but you can only, it kind of reopens the divorce case, but you can only do that if there's been a significant change in circumstance. So this is where I said moving, and certainly moving children can be a significant change in circumstance, so that decision is opened up again and there's another hearing. But it has to be something important. Sometimes you have batters that will go in and they'll file to modify, and threaten to do that every single time anything happens with their ex-partner. Partner is starting to date somebody. Oh, that's a significant change of circumstance. And even though the court may not hear that and may throw it out and say, no, that doesn't qualify, we're not rehearing it, it still is a way of tangling that survivor up in having to respond to that, in often having to pay for an attorney to respond to that, and keeping that divorce process going for a very long time. I think one of the things that we make a mistake around is believing that the word divorce is a noun and it's something that happens and you do it and you're done. And in fact, divorce is a verb and you are in the process of a divorce. You are getting divorced. You are divorced. As in a verb, it's an ongoing action for a very long time until you get that decree, and actually often for a very long time after that. It's often not a process where suddenly there's an ending in change of relationship or change in the abuse or anything else. So, is that all I have to say about the process? That is all I have to say about the Iowa process. So it's an introduction. If it seems scary, that's what people can expect. Go to 598 and read what it says there to become more familiar. If you're like, what does that mean? Just Google Iowa Code 598 and it will pop up on your screen. But again, as I said at the very beginning, what strategy-wise, what's going to work for one person? What do I ask for? What's going to, do I go ahead and ask for a waiver? Do I present about domestic abuse? Would it be better if I just didn't even bring that up? Would I get a better decision without muddying the water? That's going to depend case by case by case. So I haven't seen any hands while I've been talking. So I'm waiting to see if I have any now. Instead, I'm seeing people blink out because I know I ran over my hour. Okay, well, thanks again. The PowerPoint should be headed your way if it's not already there, and I will have this recording available within the next few days on our YouTube channel. And if there are specific topics that you are interested in hearing, as I do training around the state, I hear people say, "Hey, we'd like to hear more," and that's where I get ideas. Or if there's something that you have a burning desire to know about, I can either put one together or I can find somebody else who has the answers to your questions and put something together for a webinar. Um, so shoot me an email. And that's all. And have a good rest of the week. Thank you.